All rise. The Court of Appeals Division 1 is now in session.
You may be seated, thanks. We are here on our case number 1, CACV170775, Best Western versus Oakland Park Inn et al. Well, this is an unusual situation. Let me make a record. We have, I see that Mr. Anderson, counsel for the appellants, is not present. He did not return the oral argument appearance receipt once the court emailed it to him in the ordinary course. We emailed him twice last week to ask him to respond, and we telephoned him, and we heard nothing from him. An assistant then telephoned him last week to try to find out whether he planned to appear, and his mailbox was full, so we couldn't speak to him, and nor could we leave him a message. We have thought about whether to proceed with the argument given his failure to appear. The panel has decided that, given that it was Best Western that asked for the argument, we would proceed, at least insofar as we have questions to ask Best Western. So, with that, Ms. Swan, you have 20 minutes for your argument. I'm not sure we'll take that long. And I should say, when you approach the podium, give us your name and who you are representing, because we are recording the proceedings. We've discussed the case in our conference. We've also reviewed the record and reviewed the briefs. So, with that.
Good morning. May it please the Court. I'm Michelle Swan. With me is my partner, John Fruitkin, on behalf of Appellee Best Western International. Let me start with this. What questions can I answer for you?
Thank you. Thank you. I'll tell you, I've got questions about the default, the entry of default as a sanction. I didn't see that Best Western addressed the Seidman case in its answering brief, and it seems to me that case may apply, given that what happened here is counsel failed to obey a pretrial order. So, are you familiar with the Seidman case, and how does it apply, if at all, here?
Yes. So, what happened here is on January 23rd of 2017, Kutak Rock obtained an order allowing them to withdraw. And then within a couple of months, Mr. Anderson peered through a limited representation notice. And it said, I'm going to handle everything but the trial. And so when the trial was set in April, I raised the question with Judge Warner, we need to clarify because we don't have trial counsel present. And at that time, Mr. Anderson said, well, I'm in negotiations with the client. I'll probably appear as trial counsel. So then we get to June of 2017, and Mr. Anderson said, here's a settlement proposal. By the way, I don't represent these guys anymore. Well, there hadn't been anything officially filed with the court, and under Rule 5.3, we started getting worried that we had this, November 6th trial date that we didn't want to lose because the case had been pending for, over 2 years at that point. So this wasn't really a question of punishing counsel for failing to appear for those two hearings. It was really a question of counsel was never committed as counsel. Counsel was there to do discrete tasks, but we Best Western and Judge Warner knew that whenever sort of the client was pushed about whether the client intended to keep litigating its claims, it had counterclaims, and defending the claims, there was no clear answer. So I can't find any case in Arizona, I couldn't find any case anywhere, quite frankly, with these kinds of facts, because while you had a counsel of record, it was sort of a counsel of record. And there was a hearing before Mr. Anderson appeared where Mr. Johnson appeared and submitted documents that said, I represent her. I'm the general manager of the property. I represent her. Judge Warner and I were both uncomfortable having him appear because, of course, he's not a lawyer. He can't appear on behalf of the corporation. And there was no evidence that Ms. Marquez was not competent. In fact, I deposed Ms. Marquez, and she certainly was competent. So it was just a very unusual situation to have him present. So, but that, went forward, and then we had the Zimmerman hearing, and he knew exactly what was going on with the case. He knew that Judge Warner was concerned about how things had happened. And
when you say here, you mean Johnson or Anderson?
Well, both of them so both of them were at that Zimmerman hearing, Mr. Anderson in person, Mr. Johnson on the phone. And at the conclusion of that Zimmerman hearing, Judge Warner went out of his way to say, well, we have an unopposed motion for entry of default judgment, so I will just rule in due course. So at that point, either Mr. Johnson, the client, or Mr. Anderson, the attorney, could have said, we would like an opportunity to respond. Neither of them said anything like that. There was no response to the motion for entry of default. There was simply no participation at all, which is kind of how the case had been languishing since Kutak Rock withdrew in January of 2017.
Okay.
That said, Anderson continued to be counsel of record.
Correct. But if you look at, after that Zimmerman hearing, every time Mr. Anderson appeared and filed something, he specifically said, this is my limited scope representation. So if you look at the notice of appeal, it says, I have a limited scope representation, and I am filing this notice of appeal pursuant to that. If you look at the opening brief, it notes a number of times that he is filing this pursuant to his limited scope representation. So again, I am not challenging the wisdom of Rule 5.3 or allowing limited scope representation. I am simply saying that in this case, the way it has worked is that it's very clear that discrete tasks will be done, but there will be no holistic approach to actually litigating claims. And again, if this was just a matter of Oakland Park defending Best Western's claims against it, I think that's different than here, where Oakland Park did that, but Oakland Park also claimed, like over $1 million in damages as a counterclaim, but it just wouldn't commit to actually litigating those claims. And at some point, the Superior Court has to say, this case has been languishing for 2.5 years. We need to resolve this case. And I think Judge Warner correctly exercised his discretion after months of a record to say, I'm going to go ahead and dismiss those counterclaims. I'm going to strike the defenses. I will give you an opportunity through the Zimmerman hearing to tell me why I'm wrong. I will then keep, and he kept, the motion for entry of default judgment. It did not go to a commissioner, which is typical. It stayed with Judge Warner. No response was filed. No objection was filed. No Rule 60 motion was filed. I mean, Judge Warner gave them every opportunity to try to indicate that they had an interest in actually litigating their claims, and it just didn't happen.
Did Judge Warner consider lesser sanction?
I believe he did inherently. So, and by that I mean he didn't say on the record at the Zimmerman hearing or at the August 2017 third hearing. He never said, I'm considering a lesser sanction. But I think implicit in his findings at the Zimmerman hearing that there was no undue prejudice and that there was no excusable neglect, I think he had to have inherently found that because Judge Warner really gave many opportunities to Oakland Park, and
did he investigate or ask whose fault the actual default was, whether it was counsel's actions or his client's actions?
Well, he did investigate that because what was filed before that Zimmerman hearing was a emergency motion to continue. And in that emergency motion to continue, Mr. Anderson said there is going to be, and then there was, Hurricane Irma. So we've got some issues, and that's why we need to reinstate the counterclaims. And at the same time, Mr. Anderson had submitted his sort of explanation of why he had not appeared. And his explanation was, my email didn't work for just these notices. So the emails worked, but all of a sudden when the notices from the court were coming in, all of a sudden he didn't get these notices. So Judge Warner asked Mr. Johnson basically, you know, what's your position on this? And Mr. Johnson at that time reiterated, well, we don't know if we're going to have counsel for the trial or not. We've been interviewing lawyers. We don't know. So there was never really a clear answer from Mr. Johnson about why Mr. Anderson was still counsel, whether he was still going to be counsel, whether he would be appearing at trial. And Mr. Johnson never said anything like, Judge, don't punish me because of the bad behavior of my lawyer, or didn't say anything like, you know, Judge Warner, we didn't know that these hearings were scheduled. There was nothing like that. It was just sort of, you know, there was a hurricane, the hurricane passed, and Mr. Johnson was still totally noncommittal about whether he would proceed with the claims or defenses and how he would proceed with the claims or defenses.
Doesn't the judge have to make that call, have to make a determination whether the failure to respond is due to counsel or to the client before he imposes the sanctions like he did here?
Yes, I think you're absolutely correct. I don't think, however, that has to be a sort of proposed finding of fact and conclusions of law, anything like that. I don't think there has to be anything that is that clear in writing. I think when you review the transcript, you will see very clearly that Judge Warner did consider who was at fault, and Judge Warner did decide that sort of both parties were at fault, or there was enough fault that he was not going to vacate the previous default.
What statements or indications did Judge Warner make that point?
Pretty short proceeding.
It was. I agree. I apologize. Let me. The court again spent some time with both parties, Mr. Johnson and Mr. Anderson, discussing why notice hadn't been received. And after hearing both of them, he stated that, he didn't find excusable neglect.
Do you read the transcript to show that Judge Warner asked Mr. Johnson whether he received the notices of the status conferences? Where does it say that in the transcript?
It does not, Your Honor.
Okay.
And if Mr. Anderson said, I didn't receive the emails, the implication from this is, if I had, I would have been here.
Correct.
Right?
Yes.
So that's more, whether that's true or not true, that has to do with counsel's decisions, not the client's decision. Correct?
Yeah. Yes, you are correct. Yes.
So that kind of goes against any implicit finding by Judge Warner that the fault lies not with counsel but with the client.
Well, I respectfully disagree, because Mr. Anderson again said, well, this is the email I've always had, this is where all my emails go, and he got some notices because he got the Zimmerman notice. So he was very selective about what emails he did and didn't get.
But that goes to the attorney, not to the client, though. It is my point.
Right, and I absolutely agree. I also think, however, that the Superior Court, the Court of Appeals, the Supreme Court relies on parties who are represented by counsel. Those communications go to counsel, and there's no exception for, if counsel seems unreliable, then we will go ahead and reach out to the client directly. So if there's some kind of issue there, I think that needs to be dealt with between the client and the lawyer. But I don't think that Judge Warner or the Superior Court Clerk's Office should be faulted for not reaching out to the client directly. And I don't think that Judge Warner should be faulted for sort of expecting that when communications from the court were sent to the lawyer, that the lawyer is then the responsible party.
But I'm not saying that anyone should have taken extra steps. But my understanding of the law is that when you have a sanction as serious as this, it must be the fault of the client and not simply the attorney.
Correct. I agree with you. And to be perfectly honest, I think if the client would have filed an objection to the motion for entry of default judgment and said, hey, this is the lawyer's fault, this is not my fault, I don't know that Best Western would have strongly objected to that, right? Best Western probably would have said, okay, let's reopen that motion. Or if they would have filed a Rule 60 motion to set aside the default judgment, saying, don't punish us for what our lawyer did, again, I think that that's something that the trial court probably would have been inclined to set aside the default judgment. However, Neither of those things happened, and the time to have filed the motion to set aside the default judgment was in April of 2018. But I absolutely agree with you. I think that had somebody raised that issue, saying this is the lawyer's fault, this is not the client's fault, probably would have been successful, and we probably wouldn't be here right now. But neither the client nor a new attorney nor Mr. Johnson took that position at any point after the Zimmerman hearing.
Thank you. I should ask, there's one individual in the courtroom I don't recognize. Is Mr. Carl Anderson here in the courtroom?
No, Your Honor.
Thank you. You may. Thank you. All right. We'll take the matter under advisement and issue a decision in due course. Now we'll recess for a bit for the next case. Thank you.